Hi everyone, and welcome back to Bowdie Shorts, making law make sense in 15 minutes or less. In the last episode, we looked at the declaration of trust and asked, have I created a valid trust? But today we're tackling the next step, because creating a valid declaration of trust is only half the battle. A trust is not fully effective until it is constituted. And today's big question is, have the trust assets actually been transferred into the trust? So the big picture with this is that we have to remember that creating an express trust requires two things. Step one, a valid declaration of trust. Step two, the trust property must be put into the hands of the trustee. Only when both steps are complete is the trust constituted. Think of it this way. The declaration is the instruction manual. Constitution is putting the trustee in possession of the property. Without both, the trust may fail. So let's start with the simplest case. The settlor declares, I hold this property on trust. In other words, the settlor has appointed themselves as trustee. Now, why is this easy? Well, because the settlor already owns the property. They already have the legal title. No transfer is required. The moment the declaration is valid, the trust is created, the trust is constituted, job done. Now, the more common problem, and most examination questions would look at this, would involve a different scenario, where the settlor appoints someone else to act as trustee. Now, an additional step is needed. The trustee must receive the legal title to the trust property. Now, why does this matter? Well, because trustees cannot manage property they do not legally own. If legal title never reaches the trustee, the trust may never become enforceable. Now, how legal title is transferred actually depends on the type of property involved. The key point to remember is different property, different rules. So for land, the settlor must execute the relevant transfer documentation, and registration of that must also be completed. The key point for SQE purposes is that land transfers require formal procedures. The trustee becomes legal owner only once those procedures are completed. Shares, on the other hand, work differently. For shares in a company, transfer documents normally need to be completed, and the registration of the legal owner of those shares needs to be updated. Again, the trustee only receives legal title once the process has been completed. Money is far simpler. Cash transfers simply through delivery. So electronic payments transfer when the money arrives in the trustee's account. Then we come to chattels. These are physical items such as paintings, jewellery, furniture, and they can usually be transferred through delivery. So the trustee receives possession, legal title follows at that point. Now let's look at this in exam question terms. Whenever property appears in a trust question, ask yourself, what type of property is this? Because the transfer requirements will depend upon the answer. Now we come to the heart of this video. Equitable maxims, and the maxim, equity will not assist a volunteer. You've probably heard this repeatedly through your undergraduate equity studies. But what does it mean? Well, a volunteer is somebody who is given no consideration. So most beneficiaries are volunteers. After all, they haven't paid for the trust. They're simply benefiting from it. So the general rule here is if the settlor fails to complete the required transfer steps, the equity will not fix the problem. Or as lawyers often put it, equity will not perfect an imperfect gift. And the practical result of this, if the transfer isn't completed, is that the trust generally fails. The beneficiary cannot force the transfer to happen, and that is the starting position. Now, why is this rule important? Well, because otherwise people could ignore transfer formalities and could ask the courts to sort things out later. Equity generally refuses to do that. Fortunately for students and beneficiaries, there are exceptions. And the most important is the every effort rule. So the question to ask is, did the settlor do everything they were required to do? If yes, equity may regard the transfer as complete, even though the legal title has not yet arrived. Now, students often remember this as the student has done everything in their power. All that remains is an action by somebody else, the proverbial point of no return. So as an example, suppose a settlor signs all the relevant paperwork and sends it to the appropriate body for registration. The registration simply has not happened yet. Well, under this particular branch of our equitable maxims, the settlor may have actually done enough. So the SQE shortcut here, ask, has the settlor passed the point of no return? If yes, think about the every effort rule. Now we come to another exception, strong and bird, one with a slightly unusual fact pattern. See, the problem here was that you've got to suppose the settlor intended to create a trust. And you've got to also suppose they failed to transfer legal title, and then suppose that they then died. Ordinarily, the trust would fail. But what if the intended trustee subsequently then acquires legal title through the deceased's estate? The result is that the trust may still become effective, provided that certain conditions are satisfied. Now, as a practical memory aid, think intended trustee later receives legal title through death. That's the situation where strong and bird enters the conversation. Now we get to choitherum. This is the final exception, and this is a favourite with examiners. The scenario this time is the settlor declares, I appoint myself and somebody else as trustees, but then the settlor never completes the transfer process. Problem? Well, the answer is not necessarily. Why? Well, because the settlor is already one of the trustees. They are already subject to trustee obligations. Their conscience is affected. And the key idea here is that once the settlor has made the declaration, it may be unconscionable to allow them to deny that the trust exists. Therefore, equity may enforce the trust. Bringing it all together, trust problems should be tackled in stages. First, ask, is there a valid declaration of trust? If not, stop. The trust fails. If yes, move on. The second question, has the trust been constituted? So have the legal title and the property reached the trustee? If yes, you have a valid trust. Third question, if the legal title has not passed, ask yourself whether an exception applies. Consider every effort, strong and bird, choitherum. Now, what's Bowdie's bottom line? Well, every constitution question can be reduced to one issue. Has the trust property actually reached the trustee? If the settlor is the sole trustee, a valid declaration is enough. If someone else is the trustee, the relevant transfer rules must normally be followed. Remember, equity will not assist a volunteer, but equity occasionally softens the blow through a handful of carefully controlled exceptions, and that's exactly the framework you'll need for SQE trust questions. Thank you for watching this video in the Bowdie short series. Please look out for other videos in our trust series available now on YouTube.